Hi, Danny again. We're at Exhibit G, and I love this name because now I know who they are. The name of the section is Imposters dash Fictitious Payees. How does that pertain to loans today? And I want to go back to the last video, Carpenter versus Longan, where they said the contract is both documents. The security instrument, deed of trust or mortgage, which says your house will serve as collateral for the loan that you're getting and someone gives you. If you sign a promissory note and you don't get what's promised, the note is no good. So you are offering to pay back $200,000, and you've offered to put up your home as collateral for the $200,000. If you don't get $200,000 from the person named on the note, then there is no note. It's void. And then we have an imposter, a fictitious payee. Someone has said they loaned you money, but it wasn't them. It came from somewhere else, and we'll explain that another time. These are meant to just describe the law piece by piece, but what splits the note deed of trust today? If you go get your documents, your file folder from closing from the title company or whoever closed, the attorney, and if you get a copy of your note as it appeared at closing, which is all they're ever going to get you anyway, that isn't your note. Your note is being held by the holder in due course. And the deed of trust, and read the words. MERS is mentioned 95 or 96% of the time. And by the way, I don't know who made that up. I think it's 100%. It's 100% all the ones I've seen. MERS is given powers by the lender, the originator, your originator, to sell, transfer, assign, to be the beneficiary, to be the sole nominee of Washington Mutual, Wachovia, People's Bank, Fred's Little Bank somewhere downtown, Bob the broker. But they're not loaning you any money. They're brokering the deal. They're introducing you to a lender. The lender's going to loan you money. That's the name. The person that gave you money has got to be on the note and the deed of trust. And the terms must match. MERS is given powers, I sometimes say fantastic powers, to sell, transfer, and assign your loan to someone else on behalf of the lender when MERS has no money in it. It makes no sense at all, but we like it. It's perfect for us. Because now go to your promissory note. MERS is never mentioned. MERS cannot assign your note, the senior instrument. It is essential, Carpenter versus Longan. And the deed of trust or mortgage, your house, is incidental. They have different terms. They are split. The moment you sign them, those documents are no good. They were never any good. 500 people per month are being foreclosed on the deed of trust in Jackson County, Missouri, but no note. Can't happen. If you just stand up and say these laws, you'll get a long ways, and we'll help you do it. Bring those questions. Go to the website, fill out the form, write them, we'll get back to you in one day. And I mean it, I really do mean that. I'm not doing this just to do a webinar or a seminar or whatever we're going to call this. I'm doing it because this is wrong. And I'm going to have grandchildren soon. I have children. I don't want them growing up in America where people can claim to be something they're not. Holder in due course, imposter, fictitious payee, don't pay the wrong guy. Danny Hammond. That one makes me mad. This one always makes me mad. I'm mad again. And we're going to do H, I suppose, next. I'll look. Sometimes it's not there. Nope, Exhibit H tomorrow. Or in 1 minute, just click it. Thanks, Danny Hammond. Bye.